Lemon Party 1 says defamation per se doesn't need damages. They are presumed. Okay, cool. I don't think you understand how defamation per se. No, actually, we'll just go ahead and say it. You don't understand at all how defamation per se works. That's very fucking clear. I've seen you mention that a whole bunch of times because the judge says accusations of pedophilia are defamation per se in Minnesota, which is not actually true. That's a simplification of the standard. But that being said, even if they are, all right, apply summary judgment then. Oh, there's still several other elements. There's several other elements of defamation that still have to be done. Damages are presumed. Cool. Great. Doesn't matter. On that one, if it's protected speech, it's still protected speech. Just because it's defamatory per se doesn't mean it's not protected. This is something people get wrong. The accusation of the assignment of defamation per se to a thing still requires the defamatory statement to be false. Still requires it to be uttered by the defendant about the plaintiff to a third party. Again, falsity. Damages are presumed. Those damages have to result from the defamation still, and they have to still show the requisite amount of fault, negligence, or intentionality, reckless disregard for the truth, or knowledge of the falsehood. All of the elements still need to be satisfied. In defamation per se, one element is satisfied, and that is merely that damages exist. That's it. So you can say it as you have been in chat over and over, but something being a defamatory per se statement is not a ruling that the statement was defamatory in the case. I don't know how to tell you that otherwise. It's just a presumption that damages exist. Now, you still have to actually prove the damages for the judgment. That's another thing people misunderstand. Presuming that damages exist. Well, damages includes any amount from 1 cent to infinity. Okay, defamatory per se, damages exist. Now, to recover those damages, you have to show evidence of the damages. Just because they were presumed at the fault stage of trial does not mean you get awarded something at the end stage of trial, at the judgment phase. Because the courts are making people whole for the damage they got. They're not punishing an activity. That's criminal court. So let's say that statement, sure, damages are presumed. Okay, he's damaged by my statement. Cool, great. Accepting that arguendo, what is your argument for the value of those damages and what are you basing it on? You won't be able to answer that. You won't be able to answer that because Montagraph has not told you how much damage he suffered. Hasn't told anybody. He can't. Lemon Party says, great, then off to trial this goes. Why? If the damages are presumed, it's not in dispute. Like your intent, I know, listen, I see you in chat. You intentionally and willfully read this against me. That's fine. I don't care. It's funny, but you don't understand how defamation per se works or much of anything. If this thing needs to go on to trial, sure, apply the summary judgment standard. If Montagraph has shown that he's likely to prevail at trial, and the judge could rule that, but we should be applying Colorado law. That's what the choice of law states. Or the conflict of laws. The problem that they have, they really don't want that summary judgment analysis because they don't have the elements. They don't have them. I can guarantee you there are at least 2 elements that they don't have. We don't have to dispute a single fucking fact because they don't have 2 of the elements. Sorry, and they know it's fatal to their case.